Thank you. Thank you for joining us. Am I still audible to you? Because I think when I put my mics, earbuds, maybe some problem.
I'm hearing you.
Oh, excellent. Good. Because putting earbuds means I'm not disturbing anybody around here.
I should do the same, but if I find my... Okay. What's the weather?
Sorry?
What's the weather in Udaipur? It's a good day today?
It's a good day. It's a nice weather. It's a nice part of the year. It's pleasant, usually, at this time of the year.
I'm just a little bit regretfully informing you that today is a very, in a large scale, an exam going on in Rajasthan state.
Okay.
So the capital city, the pink city of Jaipur, is stranded because of network. They have deactivated the network. So the whole Jaipur city, but not, and many other cities of Rajasthan also. Although locally I belong to Udaipur, so here it is not deactivated. So we are lucky to hold it. So we are going through the recording process. So I would continue with my introduction and everything, and we'll just proceed with our discourse. People will join slowly and gradually. And as it is a...
Just
Pardon,
one
sir?
question. Just one question.
Yeah.
You said you're recording this program.
Yeah.
Can we get the link? Are you going to upload it somewhere? Can we get the link of that recording?
Yes, sir. Yes, sir. Like since 15 September, I've been holding some webinars like International Day of Democracy, International European Day of Languages, and then International Internet Day and Information Development Day. So all those recordings are available in LinkedIn and in YouTube.
Oh, great.
So I have everything uploaded. Even I think in Twitter I have not done so, but in LinkedIn and YouTube and might be Facebook I'll be uploading later on.
Okay,
so constantly
sure. So
I'm very much occupied.
So we'll get the link of it. Fine.
Yes, sir. Yes, sir. So that's why we will proceed with our discourse because so that we can finish the things by 12:30, and later on for you viewers and for their comments we will be accessing later. So let's proceed. So with a very happy note of good morning greetings and note of sincere regards to all the honorable guests, speakers, and fraternity of multidisciplinary academics, I invite all scholars and global local citizens to attend this webinar to celebrate the Foundation Day of United Nations Organization, 24th October. And indeed, this United Nations organization has enabled people across the world to build their capacity to express their deprived subjectivity. But this organization has also transcended the sense of humanity as a symbol of international peace, security, safety, and sustainable development. This is to inform you that United Nations Day marks the anniversary of the day in 1945 when the United Nations Charter entered into force. UN Day, celebrated every year, offer the opportunity to amplify the common agenda, especially in the post-pandemic world. It has really contributed a lot world across through its world community, enlightened community, to spread whatever affairs they can solve. And in that, judiciary and legislation of the world across have been very much activated to stimulate the process. So this substantial goal of health, security, and international cooperation is a common agenda of United Nations. So 76 years has gone by to retrieve hope for global unity, and since then the organization has been working for actions and solutions that way to ignite transformation and to guide civil resilience to mobilize global goals. And before I introduce my honorable speakers, I would like to elaborate also on my host university, that how it is somewhere in a very small manner, but with bigger vision and mission, working upon the sustainable development through education. This Bhopal Renewals University is president is Professor Nar Bahadur Singh Ji. Coincidentally, as today our own institute is occupied in the exam, some Rajasthan government administrative exam. So I think 1 lakh people are engaged, or 1 lakh candidates are engaged in appearing this exam today in Rajasthan state. So therefore, all educational units are quite engaged. So our Professor Nar Bahadur Singh Ji, the president, and the chairperson Shri Pradeep Singh Ji Singoli. There is a two. We have a big trust. It's known as Vidya Pracharni Sabha, and that big trust was founded in 1923 by the Maharana, His Highness of Mewar State, Bhupal Singh Ji. And that trust since 1923 working towards this academic integration, and until in contemporary times, his grandson Shriji Hazur Maharana Mahinder Singh Ji and his own son Vishwaraj Singh, they are looking into the matters through this trust. Now this trust is functioning as Bhopal Noble Sansthan, and this Sansthan or this organization has got 18 units spread in the local area of Rajasthan. And Bhopal Nobles University, this BN University, is one of its educational unit. Which had its inception in 2016. And so 5-6 years have only been there of its establishment. So this is the background. And then, the most important thing is the trust is an elected body. And with common referendum, they run the administration. And this administration is contemporarily in the hands of the chairperson, Shri Pradeep Singh Ji Singoli, and Dr. Mahinder Singh Ji Agria, the secretary, and the managing director, Mohammed Singh Ji Rathore. Today's online discourse is basically intended to observe and to strengthen the international sustainable development goals of ENO, and our schedule of is as such. We have, of course, the chief guest, our honorable chief guest. Maybe he would also join. And just let me get into my... Yes. So he is under secretary to the Ministry of Human Resource Development, as well as also at the Ministry of Justice and Law, Government of India. And he gave his consent, but coincidentally today is also the day of UNO. So the whole ministry, the Government of India might be engaged somewhere in celebration online to have been with the Prime Minister office. Then we have our another honorable chair and the guest of honor, Professor Salvatore Tolne Azariti. Hope I am pronouncing rightly, Professor Salvatore Tolne Azariti. Can you pronounce?
Okay. It's
Can
okay.
you pronounce your name?
I will change the pronunciation instead, but it is as it is written. Yes, Tolone Azariti.
Tolone Azariti. Okay.
Yeah.
Thank you, sir,
for
Thank you, sir, for correcting us. So he is currently the professor of civil law at the University of Oxford, but also he's contemporarily working for the Universidad de Buenos Aires in Argentina, the capital city of Argentina. And we have another senior advocate, additional solicitor general. She would be joining around 10:30. And she is Miss Ashwarya Bhatti, Honorable Supreme Court of India. She has been the senior advocate there. And then we have Professor Dr. Swarn Singh Ji, the chair for international politics and organization and department relating to disarmament and division, international studies. He's actually academician and professor in the School of International Studies, Jawaharlal Nehru University, New Delhi. So I'll welcome all of you, and I invite first our Professor Tolone Azarati to address and begin his address on the topic human rights in private law, structure and methodology.
Thanks so much. Thanks so much for inviting. And I wish first of all to address to the Honorable Dr. Sadav Singh, the Honorable Dr. Bhatti, Honorable Professors Warren Singh, honorable personalities speaking at this conference, kind participants and listeners. Hopefully the number that is going to increase. It's the practice of a good academic manners to begin a paper with a direct thanks to the speakers and the host organization. But in my case, I would like to convey to you in the truest form the sense of my deepest thanks and the sincere gratitude for I, as a humble academic, have the opportunity today to speak to an institution, Buchel Nobel's University, whose historical foundation, mission, and academic activities represent, in all latitudes, the best of what we commemorate today, on this date, for individuals and for societies as a whole. The sense of a man in society, the education in the discovery of his professional mission, his growth, the adoption of the critical spirit, his active contribution so that society around him is improved by his actions. It is for this reason, for this high honor that you have all intended to address to my humble self, that lastly I would like to thank the promoter of our meeting, Professor Jayashree Singh, in a special way and with great applause. Thanks so much, Professor. The subject I proposed to myself is very extensive, and I can only deal with it very briefly in the time available. So I apologize if I will take many preliminary issues for granted and known. However, essential they may be and go straight to the heart of the matter. In this sense, before going to the heart of my analysis on the structure and methodology of civil rights, I would like very briefly just to recall two elements. The first is the subject that recognizes and gives effect to these rights, according to the program of the Universal Declaration of Human Rights. Therefore, the image, the configuration of the state emerges from the functions assigned to it there. I would call it the promotional state. The second is the institutional structure in itself, that is, the composition and correlation of these rights within the same programmatic framework. It's a structure that we can frame in normative pluralism. It is not based on a single value or apex right, but on the equal relevance and the normative effect of many rights and freedoms, all coexisting and all equally relevant. As it is widely known, the state in the Universal Declaration is a state that plays an active role in the promotion, establishment, and defense of rights and freedoms, which is why we call it a promotional state. Its task is not to command respect for a body of rules, human rights, and possibly intervene to repress violations. Obligations to promote, develop these rights in society, since they are imposed as such, as legal situations to be protected and promoted on the state itself. The juridical and structural form of this configuration of the state, the promotional state, is contained in the same terminology adopted in the Declaration with respect to the constant evocation, direct or indirect, of the role of the state with respect to rights. Examples of the many possible examples are Article 2, with its entitlement without distinction, and no distinction on the basis of a political, jurisdictional, or international basis. The relationship of equality and entitlement provided for in Article 7, Articles 8 and 10, with its reference to national courts and what they must recognize. Structure and proposition of human rights in private law emerges here briefly according to the following normative provisions, which we can already start assuming by their qualification according to private law perspective among rights and freedoms. Article 13 qualifies movement and residence as a freedom, while it qualifies living and returning to one's own country as a right. Article 16 qualifies as a right marriage, not a liberty, and the equal status of the spouses during the marriage. At the same time, it recognizes the family as a legal status to which it is obliged to provide protection, a natural group entitled to protection by society and the state. Article 17 qualifies individual property as a right. Article 18 and 19, freedom of thought, conscience, religion, opinion, and expression, are important here because they help us lay the foundations of the composition between civil rights I alluded to above. The normative tenor of the Declaration is undoubtedly individualistic. The standard subject of each provision is an ideal type transposed as everyone. The list of rights and freedoms subject to provisions, both personal and patrimonial, like property, are individual in nature. This implies the assumption of an initial pluralistic and individualistic paradigm as an effect of the Declaration provisions. Why is very important for the civil lawyer all these? I will try to summarize it briefly with some arguments. Who is the addressee of the Declaration's provisions? As we've seen, undoubtedly, the state in the promotional function mentioned above. Therefore, its governmental activity and its function as primary legislator, but also in the entirety of its institutional body, therefore, first of all, the jurisdictional courts, before which human rights issues can be invoked and enforced. Simplifying this argument very considerably here with respect to its greater complexity, assuming the relationship between the Declaration normative body and the individual as their recipient, we can say that this enforcement, according to different national systems, sometimes can take place directly, the so-called direct application, through the request at the course of one case in question of the direct efficacy of the provisions of the Declaration. Sometimes this can take place indirectly, when recognition and enforcement by the courts can be invoked only on condition that there is a prior domestic act of legislative recognition of human rights. Let us go beyond this distinction and put ourselves in the perspective of the court, which must recognize and give effect to the pluralistic and individualistic system of human rights. What is the problem sequence that the court has to deal with? The first problem relates to interpretation, as a typical of jurisdiction in private law, that is, as the main activity of the courts. Interpretation in private law identifies, recognizes or not, totally or partially, gives effect or not, may also redefine in their content and substance the civil rights claimed by the subject. Indeed, systematically, the cases that a subject can invoke in private law are not as homogeneous as in criminal law. Basically, private autonomy operates in the composition of the token present in the concrete case and in its claim before the judge, whereas in criminal law the case is normally, on pain of constitutional voidness, characterized by mandatory action by prosecutor and specificity. That is a system of warranty for the individual from the punitive power of the state. The criminal law must be precise in establishing the abstract case and the effects in terms of penal sanction. Therefore, in addition to a general hermeneutic model, the notion of a pluralistic society contains elements directly effective on what we call in German Rechtsfortbildung, which is the construction and evolution of the legal system through jurisprudential decisions. Concretely, the recognition of human rights through the decisional activity of the courts directly influences the ratio juris, the rationale of the decisions, and the justifications deduced into the motivations, as they adopt objective pluralism in the institutional foundations of the system. In this sense, linking our discourse to the typical instrument of analysis and decision-making for the judge, it should be noted that the pluralistic society is based on individualism, not multiculturalism. The individual is important as such, not because it is necessarily recognized in a group. Pluralism in civil law, when it reflects the value of the individual with respect to, for example, Article 18, religion, conscience, does not have the same conceptual value as a recognition for religious groups. The individual is recognized, not necessarily the group. Religion and conscience, on an individual basis, imply the reception of a plurality of values of different nature and origin, which from a subjective point of view can be pursued both in organized and in individual form as legally protected ends. This, as can be understood, implies a plurality of relevant goods, material and immaterial, incorporated and protected as such by law. In the legal sphere, pluralism therefore implies, first and foremost, the protection of a multitude of values that are perceived as such, multiple, equal, and not organized in a hierarchical form such that none of them can be considered overarching. However, the civil law system in a pluralistic society does not accept the founding values in the form of a catalog, as normative elements aligned according to sequence and operating autonomously within it, rather finding their relative systemic connections on a normative and interpretive level. Therefore, it is quite clear that in civil law, human rights can be complementary or mutually limiting, so that the question no longer arises on the merely static level of recognition by the courts, but is assumed on the dynamic level of their exercise. What is the extent and the measure to which the exercise of a right or a freedom is admissible, and what is the limit beyond which their exercise is considered to entail a violation of the freedom or right of another individual? We thus enter the structural dynamic of the private law system when we begin to take up the subtle yet inevitable subject of the conflict between rights and freedoms within a pluralistic society. Rights and freedoms may present certain characteristics, chief among which are their potential for mutual conflict and their incommensurability. The latter, incommensurability, is a reflection of a question that remains unanswered by the approach of legal rationalism that contributed so much to the drafting of the Declaration. If the interpreter, the court, examines a case of conflict between equally fundamental rights or freedoms, by what rational criteria can it ever measure the resolution of the conflict, given that, unlike material goods and entities, they exist conceptually, but are by their nature incommensurable in quantity, in weight, and extent? Jurisprudentialism has often answered this question with mere fictions, fictio juris, or allegories, even when the interpretation makes use of techniques named after quantitative allusions such as weighing, in German is abwägen, or weighing, that is gewichten in German. In reality, its object does not contain dimensions that can be attributed to units of quantity or capacity that are the values, and the rights and the freedoms. For reasons of timing, I must evade many issues that will be necessary. So I go directly to what I consider to be the fairest solution, according to a German civil law concept. The interpreter, the judge, must decide according to Zusammenspiel, to coherence of the system. That is, he must elaborate the rule according to the coherence and non-contradiction of the instances of concretization that is examining in the concrete case with the instances already present in the general perspective of the system. Given this solution, it is worth pointing out, before moving on to another subject, that the system of private law recognizes in the interpretation the aptitude to break down or to decomposition of rights and freedoms into multiple, differentiated, relevant forms of rights and freedoms as a constitutive character of the same right or freedom, which is reflected on normative field with the multiple and different possibilities of concretizing them. It therefore acknowledges that the forms of application that rights and freedoms assume in the different cases are also plural, reciprocal, potentially conflicting, and equally incommensurable. Thus, the interpretive activity of recognizing human rights according to a logic of coherence with the existing recipient system leads to a degree of reciprocity of perspective, which tries to answer the following question. According to what form does the system recognize the rights and freedoms that come from the catalog of human rights? Contrary to the reiterated use by the doctrine of the concept of right and freedom, a more precise attention must be paid to the concrete subjective situations and their differentiations. Faculties, powers, parental authority, subjective rights, inalienable rights, obligations, and responsibility. These differentiations seem to allow a more congruent analysis of the phenomenon and its problematic aspects. According to a first level of differentiation, freedoms contain prerogatives that are not subjective to conditions. These prerogatives are also neither defined nor oriented towards an ultimate goal. They can also give rise in an equally unconditional manner to the genesis of the legal situation that correspond to them. From a freedom can arise powers, rights, faculties, and so on. Rights, on the other hand, contain conditional prerogatives. So if a legal situation leads to the configuration of a right, it is because from that situation it ends up integrating the condition of existence, validity, and exercise in a more concrete form. Ownership of a motor vehicle is certainly subject to different conditions of existence, validity, and exercise of the right than that of a nuclear power plant or a military tank. And these differences are ever persistent, even when we call these three very different situations right of property. The logical process of identifying the nature of the concrete case, linking the recognition of the right or the freedom with the pre-existing system, must therefore take into account the sequence of this concentric progression according to different degrees of concretization, from the abstract provision in terms of right or freedom to concrete token that interpreted as to qualify, and to which corresponds, just as progressively, the emergence envisaged by the law of the conditions that concern the configurability and protection of the various legal figures. While freedoms concern the very construction of the legal situation and are a prelude to its structural formation, the different concretizations to which the legal situation gives rise produce, on the level of effects, the different subjective positions, including right, differentiated according to the condition of existence and validity that characterize them. The same physiognomy can be observed on the functional side of the relationship between freedom and right. Freedom does not have a precise teleological orientation as right does. It does not concretely establish the ultimate hand, while it can contain multiple hands, even totally or partially alternative and incompatible with each other, both positive and negative. On the other hand, a right contains a defined taxonomy of the elements that constitute its structure and guide its function, albeit with varying degrees of precision, and which make it identifiable as distinguishable as such from other legal positions, both homogeneous, like other rights, and heterogeneous, like powers, faculties, authorities, and so on. For giving some elements of methodology, equality in private law may be associated to analogy. Private law methodology also recognizes the duty of equal treatment of cases subject to analogy, whereas criminal law prohibits analogy. If a particular right is incorporated into the system and governs certain cases, cases analogous to this must be subject to the same rule if there are no significant differences between the two categories. Example is the Article 17 of Declaration about Property. We have said that there are objects for which the exercise can be restricted without incurring a violation of human rights. If individual property is prohibited through the nullity of the contract because of dangerousness of the object for example, the free purchase of a tank, the rationale of dangerousness and the nullity of contract extends by analogy to other subjects, to other highly destructive weapons. Since a pluralistic legal system does not reflect in a hierarchical order the values it embodies and legally protects, then once the concretization of one of them has created a certain legal situation, the principle of equality, the right to equal treatment of what is equal, constitutes a general entitlement to invoke the same normative treatment where there are elements of similarity of the concrete case appreciable as such according to the current value system. An interpretation that violates the precepts of equality in the sense mentioned above produces an evaluative antinomy that has a direct effect on internal coherence and unity of the legal system. By constituting a violation of equality of assessment, the evaluative antinomy entails the violation of a specific obligation incumbent on both the legislator and the interpreter. In conclusion, a modern human rights perspective in private law must therefore respond to the normal evolution of societies and the increase of complexity in modern legal systems. The propensity in societies to incorporate rights and freedoms in deconstructed and fragmented forms. On this basis, it seems appropriate to employ the concept of subjective legal situation in this matter. This means that civil law attributes to rights a different magnitude and extent of activeness depending on the areas of application and the specific systematic context, which includes subjects, objects, types, and methods of exercising the right. This is because when examining the profiles relating to the application of the right or the freedom, thus assuming the distinct degrees of concretization, the concept of situation is suitable to guarantee the connection between the concrete formants of the case of the particular token deduced from the jurisdictional practice and the different abstract type of distinct nature to which the institution applies. This allows to highlight the complexity of each case in relation to the individual hypothesis, grasping the specific ratio decidendi in its peculiarity, according to, for example, whether the right or the freedom cases operate with respect to a mandatory rule or a non-negotiable rule or a dispositive rule, according to the interpretation that is given of the context. As for the specific position of the persons to whom entitlement is recognized, the concept of situation makes it possible to adhere to the particularities of concrete cases while removing the systematic need to bring the various contents back to a single abstract case, which at the end would, as we understand, lack real generality of application. This differentiation that civil law brings to light is surely a sign of the resilient virtue of human rights and the Declaration, and also of the strength that they can still radiate in the world. Thanks so much.
Thank you, Professor. You have really elaborated very much impressively upon the construction of human rights, which has been for centuries a subject of logical orientation to build resilience, not only against contaminated emotions and human rights abuses, but also, your address is actually giving us insight towards emotional diplomacy in the field of jurisprudence, especially United States, United Nations organization has to handle, number one. And number two, what I feel, I may put you a question now. Do you think is it hard now for a pluralistic pattern of societies to deal with this kind of emphatic implications regarding the coherence of law and the legal reach uh, to those people who have been very much affected, or to those societies very much affected by the post pandemic deprivations? Don't you think a kind of binary has been into emergence with regard to emotional diplomacy among the developing, developed, and undeveloped nations?
Thanks for the question, Doctor. I sincerely believe that we have no other way that the kind of integration of coherence that I tried to highlight at this moment, because we in the past had a lot of other emergence, different nature, maybe different characterization, but even in this case, we have not the good result that we were expecting from human rights system and enforcement since the beginning. The only way to which, through which we can have a perspective in all the cases of emergence, even in the case of this post-pandemic, is to realize that the kind of cooperation that the human rights as such from United Nations can be enforced into national systems when pluralistic, I repeat, is something that is more internal to the systems. It is not, difference between systems or difference between states. In state is a form of incorporating among different individuals, all members of the same society. Well, in this case, human rights maybe enforced in basically in only one way, as a standard. We can employ them as a standard for which a government must justify itself in case of violation. Through which the government must have a guide leading through this kind of emergence. Through which I believe that many other problems may be justified. I think, first of all, to the form of compensation that during other kind of crises in the last decades have been treated human rights, when many countries decided to supersede the application of many fundamental rights, saying that they were respecting others. I have all my citizens employed, said many governments in the past. What matter if I cannot respect their right to freedom of religion, to freedom of conscience? Because you have the freedom of conscience, you freedom of religion, but you have a very large unemployment in your country. So you're not respecting human rights. This is a system of compensating what I have and what I have not reflected the weakness of human rights since the beginning. Now we are facing what we have called a state of exception in the West. And through the state of exception of the current governments facing the post-pandemic crisis in economics and in many other issues, violating in many senses the individual rights of movement, individual rights of wealthy treatment, of a consensual wealthy treatment, because in some sense many of these elements became mandatory under the pandemic crisis. Well, in this case, we must of course think of normality, but normality is how I can receive in my concrete system the human rights now. All the times in which we elaborated much more sophisticated dreams upon the, the platform of human rights, we had a tremendous failure. So this is my humble opinion. Of course, this does not entail that I dream something else. Thanks so much.
Excuse me, Professor Tolone. There is our additional Solicitor General, Ashwarya Bhati. She wants to raise some query.
Nice to meet you, Doctor.
Uh, Good morning, Professor. This is Aishwarya. I just wanted to understand your views and your thoughts on uh, the balance really of human rights. I mean, we have understood and seen that these are collective rights, and often they are competing rights. It's not like, the right of one person can trump the rights of other persons. uh, would you think that the need of the hour and the way to move forward is to really uh, recognize and experience and enjoy our rights as a collective whole?
Look, Doctor. I believe that the conflict among rights, between rights, is something natural, and it is something that belongs to the nature of self, ontological, I would say. It is something that belongs also in the form most intimate of rights and of freedoms. The one who are accustomed with Oxfordian studies, I believe that knows the famous Isaiah Berlin distinction between positive and negative liberties. Okay, well, we discovered in the course of the years and having a study much more focused that even in the case of a negative liberty, there are conflicts. I cannot stay in my home, for example, my property, to hearing high volume music, because maybe I'm disturbing the one who lives up. And while I would have the same luxury if I will live in open desert, in my home. So transferring this to law, how can summarize this? The property of your, even in the case of the property of your own habitation, the most protected right all over the world, formally protected, must be regarded as something that can change situation by situation, because your domicile, if you live in with with a neighborhood very very sensible, is different. When you, on the contrary, when you live in open desert, is different. So in some I wish to focus this. We have not to fear the conflict among rights. I believe that conflict of rights is part of of the dynamic of society. I fear the contrary. I fear the society that they say that they have not any conflict. But what we have to do is to establish according to which system we can, have a compensation of this conflict, according to which system of decision we have to establish a rule. We provide a rule defining this conflict. And this is why I fear the orthopedical construction, logical construction that go to let's weight the rights, or let's weight the forms of freedom or the form of rights each other in order to establish a provision. I prefer to say that some kind of rules, some kind of exercise of right, and some form of exercise of a freedom are integrant part of the already existing system. They are not something that comes from above, but they are part of the existing system, of a system of resolution. I mean, okay, even if the case is new, even if the situation is new. This is why, because this is something that gives more stability to the new instances to be coherent with the already existing. And this is something that gives also the security that the judge who is going to operate as a leading rule, as a binding rule, a binding system, a leading system, according to which he can decide, and leaving what is the situation that is the most important in all this context, that is the certainty of the law, the certainty of the rule. What is my fear is that in a highly pluralistic society, highly differentiated societies, like the current societies in which many people move from one country to another, bringing cultures, customs, different values, a different perspective, all part of the human being, nothing that derived from another planet in the in the universe. Well, in this case, it is very important that to maintain the certainty of the system. The certainty of the system, we have only one way to do, is to according the solution to what we already have, innovating it, but maintaining the true fit in two different situations, the already existing and the new. This is why the system go on. This is my opinion, and I deeply believe this, and I deeply treating a lot of cases about this from all over the world since many years. And after all, I have seen the most stable and the most certain rules to be accorded to this kind of a procedure. Thanks for your question, Doctor.
Okay, thank you, sir. As you are the honorable chair also of the panel of speakers, so kindly stay here. Do not leave our board. Thank you, sir. So now I
I will sleep later.
Yeah, I know you today. You have I have made you to be awake very early hours, but please
I was
bear with
talking.
us.
I was talking, Doctor,
Sure,
just
sir.
because I yes.
Yes, sir. So today we have another very prominent speaker of professional standing for 23 years at the bar, and she is ASG of the Honorable Supreme Court of India, and she was appointed in June 2020 and designated as senior advocate in March 2019. Prior to this position, she had been the advocate on record to Supreme Court for the 13 years, and to her credit also had been the post of additional advocate general for another the biggest state of India, that is Uttar Pradesh, from 2017 to 2020. Amazing thing about her is that she belongs to a very royal indigenous place of Rajasthan, Jodhpur, and she had gone through all that customary and customized life of that area, and till date she is into it, but yet very prominently working in the legal services committee of the Honorable Supreme Court, and also working for the Middle Income Legal Aid Society as a panel lawyer. So let's listen to her, how she would like to work or to say something on in subsequent to the address, that how there lies a potentiality in diversity. So her address topic is potential in diversity.
Thank you very much, Dr. Jayashree. It is indeed a proud privilege for me to be here with such a esteemed gathering. And I must start by thanking the professor. He has shared his very insightful and very candid thoughts with us. I love the part where he upfront he said we need not worry about the conflict. We need not fear the conflict. And he would be more circumspect of societies where seemingly there is no conflict. So the conflict is not really the problem. The problem is resolution of those conflicts with certainty of law, with rule of law. So thank you, Professor. I know you have really gone out of the way, woken up really early. It's like still wee hours of the morning there. But we really appreciate you joining here. Dr. Jayashree, thank you very much for your very kind and affectionate words. Of course, the bit about Rajasthan is special because Bhopal Nobles University is also a very prominent university of Udaipur, and I have so many of my family members who have, who have been integral part of that university. So it gives me, it's like homecoming to me. I'm sitting here in Delhi, but it's homecoming for me to be part of this, the program. I'm extremely privileged and I'm extremely delighted to be here. Well, the potential in diversity is the subtopic that you have given to me in the broad contours that we are discussing today. Before I share some of my thoughts with you, I also would like to say that I would like this to be more engaging. So if we could have questions, comments, that makes it, the two-way dialogue always makes it more interesting. But here are some of my thoughts on the potential of diversity. Let us first understand what diversity really is. And I have to start with a caveat. I am a student of law. That's all I have ever done all my life. So this will come from the perspective of a student of law. The way I look at diversity and the manner in which I try to understand diversity is a few aspects. So one aspect would be the laws of the nature. Where does diversity pan out, or where does it fit in the scheme of the natural law, the law that exists as a natural law of the humanity, the law of the universe, exists everyone. It's not just Homo sapiens that we are talking about. It's the whole universe and all constituents of the universe. Now, there are some laws of nature which, the civilization has really weeded out. They have found it to be abhorrent to the civilized way of living. Might is right, survival of the fittest. These are also laws of nature, but they have, our experience, our journey of civilization proved that we can't have an allegiance to these rights, which would be antithetical to our existence as democratic, civilized societies. But there are certain laws of nature which have been ingrained, and actually they have been so fundamental that they have found ways into our modern legal system in the way of our constitutional laws, in the way of our human rights laws, in the way of charters which are available and applicable to countries, all countries who are signatory to those conventions and charters. So I look at, when I look at diversity is one such predominant right that has gone right from the law of the nature. I mean, look at the world that we live in. Why is it just not chimpanzees and monkeys and us and probably some fishes and some birds? If you look at, I can watch BBC World and National Geographic Channel for hours unendingly in amazement. And I learn something new every day about the world that we live in, about the animal world, about the flora, the fauna. And I'm sure all of you who follow wildlife and flora, fauna would agree with me that there's something that amazes us, surprises us every day. So the nature did not intend all of us to be of the same shape, size, color, same, all of us being the same. Our universe is not the same. Our solar systems are not the same. Our galaxies are not the same. Our planets are not the same. Now, bringing that on to the manner in which we have existed, to talk about the journey that India has had. Of course, we are a very ancient civilization, deeply rooted in value system, in culture, but we are a very nascent democracy. We are a democracy that's just 75 years old. We will be celebrating our 75th year as a democracy and 73 years as a republic, as a constitutional republic. Now, if you look at our constitution, the entire scheme, starting from the preamble to the various parts, the most significant being part 3 of the constitution, which really mirrors the fundamental rights that are available to the citizens against the state, which is really, the Charter of Human Rights, which has in different language and different form, it has been taken in. That is part 3 of our constitution. But let me take you to the journey a little before we were born as a republic, as a democratic. We were, of course, under the imperial rule as a colony of the British, but we were more than 550 princely states of different sizes, of different languages, of different culture. There was nothing similar about us. How we spoke, what we wore, who we worshipped, who we believed in, how we worshipped, what was the way of life, what everything about us was so diverse that there was really no uniting thread between us. Now, 550, and that's just 75 years back before we got integrated as a single democratic nation. Imagine, Europe is just 35, 40 odd countries, and we still see the tugs and pulls and pushes. Brexit was something that we all saw last year. And it had been a long time coming. But there are problems, there are issues, there are teething troubles that have continued. But look at India. Nani Palkiwala, in one of his lectures, doyen of our bar, he was a great legal luminary. In one of his lectures, he very interestingly pointed out that it was a miracle. India was an experiment that was a miracle for the world. Because nowhere before and at no time later in the history of civilization, 1/6 of the population of the world, and now we are 150 billion strong, nowhere before 1/6 of the civilization, which is so diverse, which is so pluralistic, which is so not similar in any way, has come together to live as a free, single, democratic country, enjoying the basic freedoms and the basic liberties that are recognized in the world. So initially, the world was looking at India with amazement as to how this country is going to actually survive, go on or not go on. But India has been an example that it has been a thriving, robust, vibrant democracy. Sure, we have our set of problems. Everyone has their set of problems. But again, borrowing from what Professor said, it's not the problems that is the problem. It's the inability to deal with the problems with the certainty of law, which is the problem. And I believe that the very fact that 75 years the country has survived, and look at the countries around us. You have to sometimes understand this in a little perspective. The countries that got, that became free countries around the same time in the world map, the countries have struggled with democracy. There has been autocracies, there have been janta rules, there has been military rules. Look at our twin country. We were both, part of the same geographical structure, the same subcontinent, the same entity under the colony, under the British colony. And when we got born as two separate independent countries, it's our twin country. That's the legacy that we have. But our twin country has a dubious distinction that not even a single elected head of the government of that country, please understand the profoundness of this statement. Not even a single elected head of the state has been removed by an election. Every elected head of the state of that country has been either overthrown by a revolution, an armed rebellion, massacred, or thrown out by some special investigation tribunal. That was the latest, but that is how it is. And look at how easily in India the power changes hands. We recently saw, even in the world's one of the oldest democracies, and debatably one of the most developed democracies of the world, Capitol Hill showed us a very different face in the last year's election. It was not a peaceful transfer of power. And what do we see in India? every day, I mean, we are so many states, and even when our national elections happen, there are state elections happening every year. We have state elections in some state or the other, and then we have grassroots politics. So right up to the panchayat level, we have the politics. I mean, we have governance of the people. Democracy has its roots from the grassroots of panchayats right up to the national level, right up to the head of our state. We are a republic, so even our head of the state is elected. In every instance, we will see that the outgoing person keeps a bouquet of flowers for the incoming person. The incoming person comes with a bouquet of flowers. There's a very nice, very cordial, exchange of power that happens. I think that is really the strength of our democracy. Another important strength of our democracy is the rule of law. Our judicial system, our constitution, and we have had, I mean, our constitution is often loosely called as the bag of borrowings, because our founding fathers who wrote the constitution, who gave the constitution to the people, made sure that it was a constitution that had the best practices of the world. That is why it is called the bag of borrowings. We have the best features that our founding fathers felt that India needed to thrive and succeed and survive as a democratic republic. So we have the best of those features from constitutions across the world. And the interpretation that it has received. So having that, having the constitution as a document which becomes a fundamental for the nation to start its journey when it's a newborn democracy. That is one aspect of it. And the second aspect of it is the journey that the constitution has seen at the hands of the constitutional courts of the country. So the fundamental features of the constitution haven't changed. We have, I mean, of course, our constitution has seen a lot of amendments. We've had 100+ amendments in the last 75 years. But the journey, if you see, it is a very exciting journey. And as a student of law, I mean, it always amazes me when I look at or glance at the journey that the Indian Constitution has had through the interpretations of the Constitution. To give you one example, there was a whole thought process. Property used to be a fundamental right in our Constitution when we started our journey as a constitutional republic. But then India needed to have land reforms. We had our problems of, mass areas and pieces of land being assimilated in the hands of a few. There was Jagirdari, there was Zamindari, all this was required because India was full of landless tillers and laborers who did not own the stake to the land that they were surviving on. So huge reforms had to take place, and those reforms required the right to property to get out from fundamental rights, because laws had to be made. And if the laws were contrary to part 3, fundamental right is part 3, that property was there. So the amendment was made to remove property from a fundamental right to make it a constitutional right. So today it exists as Article 300A, but it's not in part 3 as a fundamental right. Therefore, law can be made to regulate that right. So that whole reform system really led to the challenge to this as to what is the power of the parliament to really amend the constitution. In the decade of the 50s, the Supreme Court said that, Shankari Prasad, etc., they said, no, the parliament has absolute power. They can amend the constitution, including part 3 of the constitution. In the next decade, in the judgments leading up to Golaknath, Supreme Court said, a larger bench of Supreme Court revisited its earlier judgment and said Parliament cannot amend part 3 of the Constitution. Now it's the same part 3 that they are dealing with, but the interpretation is changing. What I'm trying to really tell you is that how dynamic the process of interpretation has been. And the next decade, so Shankari Prasad is the decade of 50s, Golaknath is the decade of 60s, and then comes Keshwanand Bharti in the decade of 1970s. It's a 73 judgment. And that 73 judgment really set that parameter and said that, so it was a 13-judge bench of the Supreme Court, and by a majority, by a whisker of a majority, but majority nevertheless, they said that Parliament has the power to amend. But since Parliament also derives its power from the Constitution, therefore it does not have the power to change the basic structure of the Constitution. And that has been a judgment, that has been a landmark judgment quoted, across the world in other democracies by constitutional courts of those countries. And the manner in which Indian Supreme Court has risen up to the occasion to deal with minority rights, to recognize the third gender, transgenders as the third gender, to throw out the consensual sexual relationship between two consenting adults, or the lopsided definition of adultery which existed in our IPC, or to even deal with some of the extremely abhorrent practices of our personal laws which were violating the basic dignities of women of the country. And the manner in which the constitutional interpretations have taken that journey has actually been a celebration of the pluralism that our country enjoys as one of the foundations of our country. And I will again, take it to that level, that while we are discussing the potential of diversity, it is extremely critical for us to understand that without the diversity, without the pluralism, there is no existence for us. It is one of the very basic, very fundamental parameters on which all of us exist. Of course, there has been a lot of debate. We live in an era of constant debate, of constant questioning. I think the scientific temper has evolved a lot. So our future generations and our current generations are asking a lot of questions. It is important to ask those questions. But somewhere in asking a lot of questions, we are also probably losing sight to the fact that diversity and pluralism is non-negotiable for our existence, not just as a democracy, but our existence as humanity. Look at I will take it a step further. Our very existence as human beings, our very existence as a blue planet, the privileged blue planet of this universe, the kind of global warming and the repercussions of that we are seeing, is because somewhere we have stopped respecting the diversity that nature has for us. And we have become a very right-oriented, society, humanity. But I think time has come for us to really take our focus into the responsibility that each one of us has towards each other, towards this diversity, towards the equilibrium. Because if we don't commit ourselves and pledge ourselves to the diversity and the pluralism of our existence, then we are threatening our very existence somewhere. And that we are reaching at a critical mass from where it will be beyond a point of reproach. So I think it is important for us to really recognize the importance of diversity and move forward by realizing that our own existence as nations and as humanity really rests on that. Those are some of my thoughts. And if we can have any questions, comments, I'd be more than happy to engage.
Yes, Professor Tolone, are you there to raise any query, remark, to give any remark? How you feel?
Yes. In the sense that I feel really very grateful to be once again to have been engaged in this commemoration, this discourse, because Dr. Bhatti carried me to the actuality, to the current situation, and even if on a macro level, like is the difference between the constitution, the political power, but confirm in some sense what was the one of the key elements of at the beginning of the Human Rights Declaration, that after all it is still the same as a problematic element, and that has not been resolved, and only recently has been focused, maybe by the jurists, by the court. And that is chiefly the right even it is a constitutional right, or whatever, the constitutional position, the legal position, maybe the power of the parliament, the power of the government, the power of the individual, the right of individual, it is defined by its concrete exercise. We cannot separate what is formal by what is concrete. The kind of picture in which, through which we describe the situation in which we live, it is not only what is written in a constitution, but also when the power of this constitution are exercised. What is the direction that the exercise takes? So, this confirms an hermeneutical perspective. I know that I bring everything to an to a more theoretical level, basically because it's. But this is very important to hear this, because you confirm to me everything. Whatever we can have written in a constitution, whatever we can have in in the most beautiful intention of the founding fathers but then what characterize and constitute the legal system is the exercise, is the dynamic of the system. And this is something that belongs to all the countries today. Even the founding of the modern democracy, like United States, experienced this problem in the last 4 years. I have not any sympathy, I have any political sympathy for anybody. But of course, we must detect that there was a very, very important struggle between the powers of this country that we normally to which we normally look at as something like a sanctification of the Supreme Court of the President of the United States, the belonging of the revolution, the American Revolution, the more deep roots in the Magna Carta, But when at the end we found the same problems also there. This brings to me to to give to support my methodological conviction. We must found the concept, including also the exercise of the situation. We cannot decide that, let's say, there is a government is protecting a right only because I put in the criminal code that whatever the violation of that right will be severely punished. No, we must assert that a right is included in the form of protection when the government has the police who's going to seek for the criminals, where all the system is protecting something that is written. Whenever we have not these, we must assemble these elements into a concept that this right is not protected. And the same is for many of civil rights, even in private law. We have seen many of these situations during the pandemic moment. Why? Because we have not the basic element of the normal assumption of a responsibility. That is the intention, that is the willingness of harming, The limitation of liberties, the limitation of the movements are due chiefly and are justified according to my opinion, because the basic element of a normal liability is disappeared during the pandemic. I'm not aware I'm going to be contagious for a fellow human when I assume the COVID virus. Okay? What means this? That means that whenever we are discussing in a very pluralistic word of whatever the situation, now we must be much more oriented. We cannot more we can no more divide the abstraction from the concreteness. We must be very, only comprehensive, all inclusive, and look at the enforcement and look at the exercise of the powers of the rights, even at a macro level, a constitutional level, parliamentary or whatever, even at a micro level. When we discuss about the current trade, the current market. But I will also add something more about macro level of constitutional level. We have no more protection against the great teeth of state. You know, this custom of a lot of government, a lot of governmental people who arrange between themselves financial crimes. This is something that belongs to the modern time in this large scale. Maybe once they were rich enough not to rule. Now it's a part of our modern world. Many people inside the governmental positions that collude with each other in order to commit crimes, financial crimes or private enrichment and something like this. These are part of the modern, the part of the, and this is how this works. It works through the legislation, through foreign activity of one country to one country, purchasing arms, purchasing weapons, or something. It may be illegal and maybe something that can be absolutely coherent with the normal and the honest governmental program. But the exercise of the situation, if we want to go back to the to a theoretical perspective, the exercise of the situation is part of the situation. This is very important because this brings us to a very stronger formalism in watching, very stronger formalism in watching at the phenomenon. It's something that we derive from the remote past, but according to my opinion, is the last, the last safe perspective in watching the modern world. Thanks so much.
I also want to share a few more thoughts, Dr. Jayashree, with your permission, please.
Yes, ma'am.
So while I want to share a few examples of, I think there was a time that the world did not really realize the strength of the diversity that we had and how it was really dependent. I mean, it was important for our existence. Just a few examples. I mean, just in the last 2 years, we have seen two heads of the states of very important countries apologizing for some things that happened 100 years back, 50 years back, 150 years back. So the first point of reference is the Prime Minister of Canada. When bodies of those young Aborigine children were found in that in the Catholic school, and belonged to that period where it was felt that you needed to, that indigenous people and their way of life was not respected, was not valued. So it was felt, the world felt that they need to be prepared for the modern way of life. Another example I saw just last year was the Premier of Denmark apologizing to Greenland for a social experiment that they conducted with some young children from Greenland. These were small young toddlers, just out of their infancy. They were brought to the mainland of Denmark to really learn the way of the modern life and to take it back to Greenland. So it was meant as a social experiment. And it was only 50 years down the line that the country realized that they had not just completely destroyed the lives of these young children who were obviously middle-aged people now, but they had destroyed their families and they had left an indelible trauma into to the communities that these children were picked up from. So there have been many examples where we have realized, and the fact. So I'm not taking away from the anguish, the trauma, the hurt, and the atrocities that were committed in the name of bringing them to civilization. But what I am today talking about is the world has realized, the top countries have realized, top countries in development and civilization have realized that it was a mistake, and they've apologized for that mistake, and a recognition of the fact that dissimilarity, everyone looking the same, and everybody, the Pink Floyd song, Another Brick in the Wall. So the system of making just bricks in the wall. The world today is a more mature and dignified place, is what I feel, and that is what gives me hope, strength, uh, for the future. That we are now in a place that we recognize, celebrate, and respect our differences, and we have that maturity to understand that dissimilar does not mean that we are agnostic to each other, or antithetical to each other, or opposed to each other in any way. There's a very interesting story again I read recently. It was a very interesting story about a bridge that was made on that is called the bridge of Choluteca. So this bridge of Choluteca was made on the river Choluteca in Honduras. This is Central America's area which is notorious for its storms and hurricanes. And whatever kind of engineering marvels they were trying to put on this river, the hurricanes were taking everything away. Nothing was surviving. So a very novel and a very futuristic engineering solution was sought after, and a Japanese firm and Japanese technology was used to build a bridge that would be, formidable, which would be indestructible. And that bridge was made, of course, it was an engineering marvel. People came from far and wide to see that bridge, and it actually made life easy for the people of the two towns that the river separated, because this bridge was really robust, and many hurricanes and storms and everything came and it survived. But soon there was a huge storm that came, which the whole region had not seen for several decades. And while this bridge survived, the river could not survive. The river changed its course, and the river, it did not flow from under the bridge anymore. It changed its course, and it started flowing from somewhere else. The impact of that was so strong. So a bridge was made which remained indestructible, but the river changed its course. So this bridge, which is an engineering marvel, that became a bridge to nowhere, over nothing, connecting nothing. Just a bridge connecting nothing. Nothing flows underneath that bridge. So I think that this bridge of river Choluteca tells us a story of of not just recognizing the problems that seemingly appear on the face of it, but to recognize long-term solutions of how we should move forward. And unless we do that as humanity together, of course, arms race, building, the race to the space, the race to build. We now have weapons of mass destruction to destroy the earth many times over. And just look at the fragility of what we are. I mean, our existence is really a miracle of nature. If the earth would have been any closer to the sun or any further to the sun, it would have been either too hot or too cold, or not enough gravity. Or, I mean, it's a miracle that we are alive. And the manner in which we need to really recognize and acknowledge the miracle and respect nature for the diversity, and not just see diversity in our laws and how we all are, but the diversity of nature, and protect it, unless we want our very existence to really become threatened. Thank you very much.
Thank you to the chair and to the Honorable Additional Solicitor General. I would like to continue with our further deliberation without wasting our time. Let's first listen to our Professor Swan Singh, the chair of the School of International Studies, Jawaharlal Nehru University, New Delhi. I welcome you, sir.
Thank you, Dr. Jayashree Singh. It's a delight to be on panel with Professor Salvatore Talon Azarati, who spoke on human rights in private law, and of course, senior advocate Aishwarya Bhatti, I apologize, who's Additional Solicitor General of India. And she very, very spiritedly brought up how not just the existence and reality of diversity, but the potential of diversity, which is reflected in the microcosm of India's constitutional and legal frame of democracy, and how that is therefore a lesson perhaps for several other nations to look at and engage. That brings the topic slightly closer to where I speak from. I come from international relations, and she had alluded to the fact that there are different ways systems are viewed. And in international relations, the mainstream two theories, for example, the realists and the liberal school of thought. Realists think that all systems are driven by power behind them or the countries that hold that power. Whereas the liberal school believes that institutions have their own persona, their own legitimacy, and therefore they bring to weight something that adds on and gives opportunity to countries that may be seen and not the most powerful countries. And I want to bring the first point for discussion, that there were several occasions when India actually threatened to withdraw from United Nations, which is not a very well-known fact. Because some of these liberal values that India held very dear to its heart, given its civilizational tradition, were under threat in United Nations because power was being used by certain countries. Today is the UN Day because about 50 nations had ratified, including the 5 permanent members of the Security Council, the UN Charter. And therefore, this is the day which is called the UN Foundation Day, though the Declaration of United Nations was signed much earlier in January of 1942. And of course, then of course you had this conference in San Francisco that happened in April and June of 1945. So it is significant to see when foundation of United Nations was laid, India was not even an independent country at that time. India was yet to become republic. So India had first joined as 4 unique examples of Belarus, India, Philippines, and Ukraine, who had joined the United Nations efforts to begin with in formulating the charter, and of course initial stages as colonies. Indeed, several other colonies of Britain, Australia, New Zealand, Canada, South Africa, and then of course India initially had joined as dominion states under that colonial system. And it's only from 1950 that India became a republic and joined as an independent state in the United Nations. So India has therefore initially seen certain stages when it was colony and dominion and then the full state that could also be seen as a changing role of India. Because when you study changing role of India in United Nations, that initial period itself provides very interesting examples of how a colony could become a dominion and then of course become a full republic, and how India engages during that period with the United Nations. That itself has been a period of understanding this whole changing role of India in United Nations. But we'll look at the last 75 years rather in a bird's view because we have a limited time for discussion today. And broadly 4 phases is how international relations view India's engagement with United Nations has evolved over a period of time, and how has India changed. United Nations has changed, but it has not changed to the expectations of many of the other countries, including India. And at least lately, it has not changed as much as the changing international order would expect it to change. So the first stage of India's engagement, if we do not discuss far too much of the change from colony to dominion to republic, is broadly defined from 1945 to 1962 where India was seen as aspiring world leader. As Advocate Aishwarya Bhatti just mentioned, that this great example of India came upon the world stage, which was a large country with a civilizational tradition, with a very peaceful transfer of power, with this whole tradition of engaging the world. Indeed, let me also share with you, it's very unusual for India to be so thickly, so seriously engaged with international affairs, international decision-making, international structures. I'm not sure how many of us today know that India is associated with the last study said 3,700 international organizations, associations, etc. And that makes India the second largest from global south next to Brazil to be engaged with global structures, decision-making processes, associations, etc. Indeed, as we speak today, about 169 of such international organizations, associations have their secretariat or headquarters in India, which again is something which is not usually appreciated, how deeply India is engaged with the world order or international system. Even when you limit it to simply intergovernmental organizations, because when you talk of all international, then there are transnational organizations that are not necessarily governmental organizations. But even if you limit to about 200 intergovernmental organizations are where India is present, of about 1,000 plus such organizations. So India, first thing, is very thickly engaged, and that partly flows from the tradition that India has had of Vasudhaiva Kutumbakam. We look at the whole world as a family, wish to engage it despite our limited leverages, limited resources. India has right from beginning had this mindset of being part of the world. And that shows that the first stage India approached as an aspiring global leader, focused on world peace related issues, wanted to be a very significant participant in many efforts that United Nations undertook during that period, whether it was war in Korea, war in Vietnam, but most significant was the Fourth Committee of United Nations, which dealt with decolonization, and how India was the leading light in pushing the agenda for decolonization. And during the initial stages, when India was looking at itself as a world leader, participating in international affairs to give a direction and then make sure world becomes peaceful in an enduring fashion. And then, of course, this first stage is also seen as the stage of idealism. The second stage, very quickly, is the stage that deals from 1962 to almost mid-1970s, when India got entangled into multiple wars in the neighborhood. So India's focus from global became rather regional and national. We had 1962 war with China, 1965 war with Pakistan, again another war with Pakistan in 1971. So India got very seriously engaged in ensuring national security, and immediate region has to be the focus. And therefore that period saw relatively low profile India was there during 1962 to almost mid-1970s. But again, India's profile begins to change because India's role in liberation of Bangladesh, India engaged in international diplomacy during that time to make sure that no negative outcomes are to be faced out of this India's contribution to the liberation of Bangladesh. India detonated a nuclear device in 1974. And that was a period when the national leader Indira Gandhi was seen as a very strong leader. And from that standing, she was engaging the world in that sense. And therefore, again, India begins to seriously engage the United Nations, but now much more from a realist perspective, much more from driving certain agenda, not so much in terms of idealistic, even to some extent, not so much normative, but pragmatic approach of pushing, for example, economic agenda at the United Nations, of new international economic order, the Earth Summit in Rio, for example, connecting development and environment. So very pragmatic, specific, and nationally we saw India also getting geared up to become a major player in oceanography or in outer space, in nuclear sciences. So that was a kind of a new India now, which was pushing the third phase of India, engagement with the United Nations, where India was becoming far more practical in how to align, engage, and use various sort of mechanisms, alignments to push certain ideas and agenda, where India would be seen as a player in that game, and not simply trying to be, global leader in the first stage. I remember the first Prime Minister was writing beautiful letters to important heads of state around the world, seeking things to happen. But now India, in the third stage now, when it comes back to United Nations, is building its own alignments with other nations, global south, non-alignment, and such alignments to push certain agenda, where India was seen as a country which is visible in pushing certain agenda. And then, of course, we talk of more recent period now. India has clearly become much more focused on economic growth and development focus. And India is beginning to be seen now as the sixth largest economy in current dollar terms, third largest economy in purchasing power parity terms. So India's economy, and therefore by extension India's market, becomes a main driver of how India begins to push its own agenda in ensuring stability and peace at global level, but also driven primarily by India's national interests. India gets, for example, waiver in International Atomic Energy Agency, partly because India's relations with the United States begin to change from 2005 or even slightly earlier. So a very different kind of emphatic and rule-making, not rule-taking, norm-making, not norm-taking country, kind of a new profile that we notice now that India gets into the current phase. The more recent, and if you talk of immediate last 6-7 years, a very hyperactive diplomacy of India's Prime Minister again has made him very visible in international fora, makes India very visible in international fora of all the multiple agencies and organs of United Nations. That is how, in terms of periodization of 4 phases, the change has occurred in India's engagement and role in United Nations. The other way of looking at change from Indian perspective in engagement with the United Nations is what have been India's strategies, or what have been the primary issues that India has tried to focus and push forward. Again, if you see, there's an enormous change that has happened in what are the issues and strategies India pursues in engaging United Nations. In the initial stages, because there were a very limited number of countries in United Nations, most of what are today independent nations were colonies. India was a leading voice in United Nations in initial stages on racialism being a concern. The last example was South Africa's apartheid, which India fought tooth and nail. Decolonization, I mentioned the 4th Committee of United Nations. And I remember M.K. Rasgotra was India's young diplomat who has written his A Life in Diplomacy, his autobiography. He describes how India was playing a leading role in decolonization campaign at the United Nations during that period. That was supported. Now, if you look at what strategy India was following, not simply making a normative design and model and speaking about it, but also ensuring there's a support to that design and that model. And India uses Afro-Asian unity, India uses non-aligned movement to push that agenda. And there's a G7 group which India is again using to align with those and push these ideas of decolonization. And within about first 15 years, the membership of United Nations as a result was to double from 50 to 100 plus. And that was the first stage when we saw visible reformation or transformation of United Nations happening, because numbers of members had doubled. Economic and Social Council, for example, which saw, in fact, India's ambassador, Arcot Ramaswamy Mudalia, who had signed on the charter on India's behalf, was the first president of Economic and Social Council, which was now to expand its membership from 18 to 27. But more important is UN Security Council, which is in debate for the last 15 to 20 years now. Because of that doubling of membership in first 15 years, expanded its own membership from 10 to 15, adding 5 more non-permanent members. Now, today, if you see, the membership has again doubled, about 193 members, United Nations nation state members. But no such transformation or expansion of those bodies has happened lately. And that is a point to be noted. And I think that is something which is of enormous significance for United Nations to stay credible. Some of you would remember the last speech recently Indian Prime Minister gave at United Nations General Assembly. He underlined this fact, that the onus to ensure credibility of United Nations today lies on the door of United Nations. And therefore, I think there is a need to ensure that its legitimacy and credibility stays robust, and that sees certain reforms and therefore expansion of some of these United Nations bodies. But meanwhile, India has not stopped and waited simply to be recognized differently or given a permanent seat in UN Security Council. All of you perhaps are also familiar how in 1949, 48, 49, there was also these insinuations and perhaps illusions of the Chinese seat, which was then held by Republic of China in Taiwan, which was not seen credible at all, because now you had a new China, the Communist China. And there was a debate whether that China, which is sitting in UN Security Council, is at all credible to sit and take that permanent seat with veto. And India was a country which was seen as a country that could replace China and take that seat. But you remember that was India's phase of behaving as a world leader, pushing an idealist approach to world sort of order, world decision making. And India was pushing China's case that now it is the new China, the Communist China, which should get the permanent seat in UN Security Council and get that veto also. So in that sense, there was an opportunity for India at that stage. It did not come. It may come, may not come. But it is important to underline that India has not stopped its engagement and enthusiasm with United Nations because that recognition or empowerment hasn't come our way. So from initial stages of focusing on anti-imperialism, racialism, decolonization, India has gradually moved to pick on other subjects. And the first most important subject which India moved forward to was UN peacekeeping. Uniting for Peace resolution had created a new instrument in United Nations which was not written in charter. It is called UN peacekeeping. UN peacekeeping is simply meant to ensure a buffer between parties in conflict if they come and request United Nations to help them. They are not a force to fight the local conflicting parties, but just maintain buffer. And they depend on voluntary contributions of soldiers, troops. And as you know, India is one of the largest contributors of United Nations peacekeeping. In fact, one of our diplomats, Dr. Shashi Tharoor, was in the peacekeeping secretariat in 1990s when we talk 1990s as a decade of peacekeeping. Peacekeeping operations boomeranged. They became so much. And indeed, the largest activity, largest single activity of United Nations, which is effective and visible around the world, is peacekeeping. So India became a major contributor of peacekeeping during decade of 1960s and 70s. Then it started also focusing gradually on other important issues. For example, I mentioned the Rio Earth Summit of early 1990s, linking development and environment, focusing much more on now regionalism, how regional organizations can also contribute to what United Nations seeks to achieve. India started being an active player immediately, for example, in its own region, South Asian Association for Regional Cooperation. Again, some facts which are not highlighted. In 1987, SAARC was the first regional organization to sign a convention on countering terrorism, which till then most developed nations was thinking is a problem for poor countries. It's the poverty that leads to terrorism. Of course, they are now in disillusion from that and they talk very differently. So India started also becoming a very, very emphatic player at global level now of terrorism, of piracy, of climate change. So there are new issues and new strategies that India has adopted. And if you look at how India has gradually evolved in terms of how it aligns at United Nations, in fact, many people today believe that India has distanced itself over a period of time from its initial constituencies of the G77 or the non-aligned countries, and has now aligned very closely to emerging powers or the dominant powers. Example would be, for example, India is now part of G20, and that is seen as a organization that can play much more emphatic role in international order, international peacemaking, international decision making, and India is an important player there in that. Or other related organizations where emerging economies have come together in BRICS grouping, or India plays a role, for example, now in pandemic, becoming the pharmacy of the world. So India has now been seen as a emerging power center by itself, and therefore does not rely far too much on developing or least developed countries' constituency, but now uses a new framework of emerging economies, middle powers, and the dominant powers. And India's relation to the United States, again, is an example here, where India has completely changed its strategies, how it engages with the United Nations. Let me put the very last point before I close my initial remarks. If you look at the very recent period, India joined this year from January 1st UN Security Council as non-permanent member for the 8th time. And an example that I always give is how India was brought in as a non-permanent member to the UN Security Council for 8th time. In a secret ballot of electing countries that will be elected as non-permanent members, India received 184 out of 193 votes of UN members. Now, that is a reflection of the general increasing acceptance and credibility of India in United Nations. India also, for example, today is chair of World Health Assembly, and that is an assembly which is becoming most important in the middle of pandemic, and India is chairing that. There's also a decade-long debate about transforming World Health Organization. India has the role to play there. So even if it is not part of UN Security Council as a veto-wielding permanent seat, India's credibility, India's efficacy, India's engagement has over time become far more effective because it has changed its strategy for a period of time. And the most recent in this year as a non-permanent member, in August, India was holding the presidency of UN Security Council. And that's a very, very important opportunity for any country, because if you remember, UN Security Council today has 15 members. And the presidency rotates on month-to-month basis. So like that, India, within first 8 months or 7 months till July, had 8th month when it was presiding over the UN Security Council. Now that period is also very interesting. You see, lately we are debating around the world what has happened in Afghanistan. Taliban took over Kabul in middle of India's presidency on 15th of August. And India, including Prime Minister Modi, for the first time in Indian history, chaired UN Security Council meeting, where a resolution was adopted regarding Taliban, because India also is the chair of Sanctions on Taliban Committee of UN Security Council, also chair of the UN Security Council subcommittee on sanctions on Taliban, and most important, also chair of a subcommittee on countering terrorism. So here is Indian Prime Minister who goes and speaks and chairs that meeting, which leads to UN Security Council passing a resolution number 2593, which sets the benchmarks, which will continue to be now important benchmarks, that Taliban must come true on to receive any international recognition. Second very important issue, in which case Indian Foreign Minister Dr. S. J. Shankar was chairing UN Security Council meeting during that period of presidency, is the one that dealt with protecting the peacekeepers from impunity attack, linking also technology and peacekeepers, how to ensure that kind of safety of our peacekeepers, which has led to another resolution being passed, which also be lasting in that sense. And of course, many other routine items that were going on. So how India was able to bring about an important consensus in UN Security Council to pass some of these resolutions during that period of presidency. And of course, India continues to be part of UN Security Council till end of next year, because it is a 2-year term. So what I always underline is that sometimes there is enormous dissatisfaction that UN Security Council or its organs or its agencies do not reflect the reality on the ground, where world has changed completely. And I underlined how India is the third largest economy in purchasing power. Parity terms, India is the sixth largest economy in dollar terms. India is pharmacy of the world in the middle of pandemic. That recognition has not come, maybe. But how India has still ensured that its credibility continues to grow, its impact on what it wants to achieve in United Nations continues to grow, and that has seen it having very different kind of strategies being adopted, very different alignments being built with other powerful nations and emerging countries, emerging economies. And that makes it very fascinating how India can sit together in quadrilateral security framework with US, Japan, Australia, and India on one side. Recently, you saw another quad introduced by Israel, United Arab Emirates, US, and India on the west of India, in West Asia. But India is also a country which is equally welcome in, for example, BRICS nations or Shanghai Cooperation Organization. So, multi-alignment of India, of building partnerships in as many sectors with as many countries as possible, shows how India's initiative in International Solar Alliance has become, 80 plus countries. Israel is last to join recently. So a very pragmatic approach, I think, is the one which has been followed by India in recent past and has made India far more effective in giving a certain direction to where United Nations should be going and nudging United Nations at the same time how to stay robust and effective. The onus for transformation today lies on the door of United Nations. And I assume that this is going to be heard very clearly, and some kind of recognition to India imperceptibly, incrementally has come indirectly, as I mentioned to you already, but I think in a more formal fashion also. There is need that international recognition in United Nations, which is the most important multilateral organization that we have, should come India's way, and I hope this will happen sooner than later. Thank you very much, and back to Professor Azariti.
Hello. Yeah, Professor Azarati, are you there? You're still there, I think, although your camera is not turned on. And Dr. Shikha, are you there? Dr. Shikha? All right. So, meanwhile, they come back. I would like one of the attendee, Dr. Fatima. Dr. Fatima, would you like to place some comments? Dr. Fatima, turn your camera.
Hi, ma'am. Yeah, maybe not the camera. Audio is fine. Okay. Thank you very much.
Okay.
I was just typing a message to you before I leave because it's already 12. I have something else lined up. This has been a very, very insightful session, ma'am. And I was not aware that you were conducting many things like this earlier. Only this popped up on my LinkedIn page. So I immediately checked with it. And all the speakers were doing such a wonderful job. Though we have known some of these things, putting all these things together on a UN day was a very, very good one. And I remember while I was in school, October 24th, UN day, we used to have an exam where we used to, write all abbreviations of the UN. But that was something that is lost on the students nowadays. They do not even know what it is. They only know it's an organization that exists to create some peace in the world or something like that. But I think these kind of sessions will bring an insight into the human rights, basic human rights, and gender rights and everything. Because that is what I do. I am a dean for faculty and student affairs in my college, basically an English professor. So I was thinking these kind of things are what the students need. So I came here to learn so that I can do it for my students in my college. So thank you very much for having me here, ma'am. Thank you.
Thank you, Dr. Fatima. for giving us such a sweet, kind of a portrait that how from the Faculty of English you are involved in the studies of international through webinar, and then applying it to amplify the focus of India and the UNO in the area of studies
Yes,
to the
ma'am. Thank you.
scholars and students. Thank you, ma'am.
Thank
We
you.
are very grateful to you. Professor Swan, I'm so sorry. Professor Tilone has to go to for a conference somewhere, and Madam Ashwarya is also to be there. You have really at the right time finished the address, but I really would like to emphasize further that you have upheld the actions and resolutions through your YouTube channel, and I would say that these are going to be intangible assets as to understand emotional diplomacy and the integration required in different spheres. So I'm really
Thank-
grateful, and through those assets, we had been able to reach you, and our institution is finally going to be very much, taking the benefits. So sorry, our institution could not cooperate so well. I told you it was real
Yes.
luck that I could continue with your. But anyway, they would be accessing you. They would be in an abstract manner, locating you, accessing you, reaching you through your all channels, whatever you have been through LinkedIn and YouTube. And so, thank you on behalf of all local and global citizens who are celebrating the Foundation Day of UNO. Thank you, sir. Thank you.
Yeah. Thank you, Jayashree. Thank you so much.